I'm talking about another possible source of legal history which can give a richer context to it, which is literature. So law and literature is a well-established and a growing area. There's quite a literature on literature. Um, and there are two main aspects to it, which I'll briefly mention, but I'm going to talk about a third one. So the two major areas are law in literature and law as literature. Less common, but the one I'm going to talk about today is literature as a historical source in itself. So law as literature involves analysing legal documents as literary text, so using the methods of literature studies on legal documents. And that can be a really interesting way to think about historical legal materials. For example, it has produced really valuable results in relation to law and the regulation of sexuality, because judgments and debates in that field are particularly concerned with using some quite complicated legal linguistic tricks in order to shape how sexuality was understood, both legally and socially, as well as who was allowed to know what about it. And law in literature looks at how legal issues have been dealt with within literary texts, novels, for example. So, to take a few examples, novels themselves can be part of legal history. So, very famously, a major element of Charles Dickens' novel Bleak House is the case of Jarndyce and Jarndyce, which drags its way interminably slowly through the Chancery Court. And the novel was itself a sort of legal history because Dickens was actually writing about the courts of several decades earlier. But it also helped to make legal history by sustaining pressure for court reform. And legal history can use novels as sources for how legal concepts were considered. And we don't have to limit ourselves to the literary classics like Dickens. So Ian Ward, for example, has looked at Victorian sensation fiction. So literature can be valuable for legal history, but I want to say a little bit about how it can also be valuable for wider socio-legal histories. So we can use it not just to consider what the courts or parliament were doing, but also to understand how that interacted with their social and cultural contexts. In other words, literature can be a valuable primary source for understanding how legal and cultural attitudes work together. And I'm going to highlight some of the factors in using literature as a source in that way. So, even where the law itself is relatively easy to reconstruct, it can be a lot harder to understand how it worked in practice. And Sophie gave us a fantastic example of that in relation to coroners this morning. Sticking with the example I gave earlier of the criminal law regulating sexuality, which is my area of research, a lot of the information we want is simply missing. There are particular challenges in reconstructing how people led and thought about and understood their intimate lives. And that's even more true when their relationships or activities were illegal as well as socially stigmatized, as was true of same sex relationships for much of history. And more generally in legal history, we're met with the challenge of what's missing. Many case papers and court records have been lost or destroyed, again, as we've already heard. There are gaps in archives, accidental or deliberate, or the information we want might never have been recorded because, for example, its subject was considered too humble, too unimportant, or too shameful. And even when judges explain their reasoning, they don't always articulate where their assumptions come from. So, in the context of my work on regulating sex between women, going back through the centuries, there are often expressions of real disgust. But there isn't much discussion of where the magistrate, judge, or politician is drawing those views from or what they're based on. So to fill in all these gaps, we have to get creative. And I hope to make the case for using a literally creative source, namely fiction, albeit that it does need to be done cautiously and carefully. And I'm not claiming this is an innovation of my own, of course, it's been done by others. For example, Nicola Lacey's Women, Crime and Character was published back in 2006, and its literary characters, from Moll Flanders to Tessa the D'Urbervilles, served as metaphors and illustrations of changing views about women's agency. My own particular interest is in crime fiction, and that might seem obvious for criminal legal history. The temptation to look at detective in fiction in particular seems straightforward. Both are about achieving justice or not when crimes have been committed. But the relationship between fiction and the reality of criminal justice is never straightforward. And I don't just mean the obvious legal errors and wonky court procedure that you see in a lot of fiction. Rather, I'm arguing the crime fiction isn't valuable so much because of its law adjacent subject matter as for its particular relationship to wider cultural attitudes. And I need to highlight a big caveat here, which I'll come back to later, which is that social attitudes are never uniform in a society or even within a specific section of society. But there are broad cultural trends and shifts, which I hope to demonstrate do matter and can be discerned in part through fiction. So I'm using this work for something other than looking at how the law's represented in literature or vice versa. Specifically, I mainly use Agatha Christie's work in order to enrich my own historical understanding of the criminal justice system's approach to regulating sex between women in the mid 20th century. And Christie depicts such relationships, but never in the context of legal processes. So the novels don't directly tell us about relationships between women in the legal context, but they can be used to illuminate other areas, including public attitudes at specific times, the dynamic shifts in attitudes, and the role of gender in shaping them. So, to take each in turn. In terms of attitudes, Christie's fiction enriches understandings of the apparent time lag between developments in specialist approaches to sexuality and legal attitudes. Briefly, if we map the evolution of medical or sexological or activist understandings of relationships between women, and then map them onto the understandings expressed in court, then there's about a generation between them. There's a real time lag. And it's tempting to say, well, yes, because judges are notoriously behind the times, but that's not helpful. But by looking at Christie's work, um, we can see that we need to ask behind whose times. Was it the magistrates and judges were particularly out of touch, or was it that they were pretty much keeping up with their peers, even if not with specialists? Well, we can't go to those judges and ask them. Most, if not all of them, are no longer with us, but even if they were, asking someone about their attitudes half a century or more ago is unlikely to get an accurate answer. Especially if they understand that their views of 50 years ago aren't necessarily acceptable today. But what we can do is turn to contemporary documents. So, as Vicky just talked about, she was talking of private papers. I'm going to suggest that detective fiction can also come into its own here. And a major reason why I use detective fiction is that it was really popular. And that popularity matters because it indicates that while the attitudes in best-selling detective novels weren't necessarily exactly aligned with dominant social attitudes at the period, they probably didn't diverge too far from them either. As Sally Mitchell has put it, successful mass fiction must speak to the readers who choose to consume it. And she was writing about girls' school stories, but the point stands for detective fiction, which Jill Plain has described as arguably the most socially responsive of literary genres. And that's particularly true of Agatha Christie. She's arguably the ideal author for this because she's the queen of crime, the most translated, best-selling novelist of all time. And as the most popular and successful of novelists, Christie clearly did tap into the dominant culture in ways that could speak to her readers. So her novels have potential value as a window into mainstream middle class attitudes. Not a completely clear window, somewhat smudged, somewhat narrow, but nonetheless a valuable one, not least because she and many of our lawmakers broadly came from the same upper middle class section of English society. As for the dynamic nature of such understandings, Christie's again especially helpful because her career was so long. She published her first novel in 1920, her last one in 1976. Or to put it in legal terms, she began writing at a time when there were no women lawyers or judges in England and Wales, only one woman MP, and sex between men was wholly illegal. By the time her career finished, the gay liberation and women's liberation movements were at their heights, and women were in the legal professions and in Parliament, although still a significant minority. Um, and her novels are each rooted in their various times. The TV adaptations can make them feel like they're in a sort of nostalgia land, but they did move very much with their times. So the viewpoint is largely that of someone of Christie's class and generation, but it does take in the big social changes, including evolving attitudes to love and sex. And when we map them against judges and lawmakers, we can see the hers and those of those who made and enacted our law were pretty much in parallel. So we can learn two things from looking at her work. First, judges were not mysteriously behind the times. They were very much of their times. But those were the times of the upper middle class public rather than sexological or medical experts. And secondly, legal and social approaches developed significantly during the century, often in mutually reinforcing ways, although not always exactly in step. So we can learn that from the novels without having to treat them as if they are factual texts or even completely faithful reflections of wider attitudes. But we do need to choose our sources carefully and treat them carefully. So if you're thinking of using literature in a similar way, here are some factors to take into account. First, sadly, we can't just choose the novels we like best. We need to think carefully about how far the particular novelist is in touch with wider attitudes and which ones. For example, you wouldn't use Agatha Christie for insight into working class outlooks. It's not there. We need to think about the audience they were writing for and their motives for writing. So Christie again is great because she was pretty unashamedly commercial in her approach to writing. She had to support her family. So although there is experimentation and innovation, she on the whole was focused on writing what would sell. Another example of audience is the genre that is being written in, because different genres have different conventions and therefore different effects. For example, in detective fiction, you need to find criminality where it is not expected, and that could lead to some very subversive representations in Christie's work. And we need to think carefully about what we want to get from the books. If we try to go into too much detail and nuance, then we risk simply examining the views of this particular author rather than a wider social context, or even of their particular narrator. So, somewhat against the instincts of many historians and lawyers, we have to accept that this is going to be a somewhat broad brush, even impressionistic exercise, not a close textual reading in the way we may be more used to with other sources. And we need to think about the ways that our chosen source won't reflect the mindset of, for example, legislators and the judiciary. And the most obvious way with Agatha Christie's work is she was a woman. Only a tiny proportion of judges and legislators were for the period she was writing in. And that might seem like a limitation, a mismatch, but it can also be a strength because we can see that Christie's depictions of relationships between women had important differences from those of lawmakers. And I'm conscious of time, so to put it very briefly, lawmakers proceeded on the basis that women, because we were supposed to be passive, not sexually desiring, responding only to the approaches of men, wouldn't find out about sex with each other unless we were told about it. Women themselves, as the mere fact that Christie wrote about such relationship shows, did in fact know that they existed. So there's a real gender mismatch. And so that throws real light on how the courts were actively having to work hard to construct sex between women as an area of specifically masculine elite knowledge. So we can see that, for example, in Cards on the Table from 1936. A relationship between two women is represented through hints and fleeting indications. The detective in that novel is Hercule Poirot, so his lack of direct acknowledgement is itself an example of male silencing. So Christie may have been aware of relationships between women, but in that novel she didn't claim that knowledge. But there's then a shift because in the post-war novels, um, it's Miss Marple who is seeing these relationships. So, in A Murder is Announced, there's a long-standing relationship between two middle-aged women. Everybody sees it, nobody mentions it. That has real parallels to what was going on in court. But also, we see that Miss Marple acknowledges the relationship, albeit through unspoken gestures. It is something that is now represented as within the realm of women's knowledge. And in Nemesis, moving forward towards the end of Christie's career in 1971, Miss Marple again decodes a relationship between women. This time, unlike the happy marital type relationship in A Murder is Announced, the one in Nemesis is a really problematic one that ends very unhappily. But it isn't the only same-sex relationship. It isn't the only relationship presented as a troubling one. The heterosexual ones are as well. So Miss Marple's expressing what Christie learned after her first marriage ended unhappily. The heterosexuality isn't an ideal either, and love of all kinds is dangerous. As Miss Marple declares, love is a very terrible thing. It's alive to evil. It can be one of the most evil things there can be. And that more critical view, again, is found somewhat also in the spirit of the times and the growing interest in areas like popular psychology. So that's kind of rushed us through what I hope is an illustration, a helpful illustration of how literature does have its own challenges and does need to be carefully, but can be a valuable source to confirm, enrich, or even unsettle our legal histories. Thank you.